Hi, my name is Mrs. Tabitha Charlene Chikea. I'm a legal practitioner by profession, and the name of our channel is Understanding the Law with Tabi. In this channel, we're going to be discussing the various laws as they apply in Zimbabwe. And currently, we know that there is a marriage bill which has been proposed to become the law in Zimbabwe. A lot of us have got questions. What will become of our marriages? What will become of the properties that we acquired during the subsistence of our marriages? Is the law taking away our rights? Is the law taking away our privileges? Are there positives? Are there negatives? Tune in as we're going to be discussing on the new marriage bill. Enjoy. The name of our show is Understanding the Law with Tabi in Zimbabwe. As we all know, in Zimbabwe, we have a marriage bill which is currently underway. A lot of people are asking, is it good? Is it bad? Well, today we're going to understand the marriage bill as it were. We're going to unpack it. But before we unpack it, maybe you're asking, what was the current marriage regime like? So I'm going to take you through the various marriage laws which exist currently in Zimbabwe. So basically in Zimbabwe, we have three types of marriages. The first type of marriage is the registered customary law marriage. This marriage is whereby parties agree that they want to get married and they go to the wife's homestead and they pay what is called in Ndebele, amalobola, and in Shona it's called roora. And after the roora is paid, the two people then go before a marriage officer and they have their marriage solemnized. You understand that this type of marriage is potentially polygamous, which means the husband is allowed to have as many wives as he wants. And in this type of marriage, it is governed by what is called the customary law of Zimbabwe. Basically, the customary law of Zimbabwe are the customs of Zimbabwe, the traditions of Zimbabwe. So what we're saying here is that when parties now want to divorce, their divorce is handled in terms of the customary law of Zimbabwe. So the woman initially is entitled to what is called the amai property. The amai property is the mombeye umai and the household effects, mainly the kitchen effects. That's what the woman is entitled to. But with the recent developments in law, the courts have been arguing that the woman must be given more than the amai property because of a term which is called unjust enrichment. So basically that's it when we're talking about the registered customary law union. There is what is called the unregistered customary law union. In this type of marriage, parties go to the woman's homestead, they pay roora or amalobola, and after paying the roora, the parties go their way and they start staying together as husband and wife. You will notice that in this type of a union, there is no registration whatsoever, which means in terms of the law, it is not a marriage. They're just people who are cohabiting in courts. And there are various disadvantages which come around with this type of a marriage. The disadvantages are that when it comes to dissolving the union, the woman mostly stands to lose out, especially if the property is registered in the name of the husband or of the man. And there is another type of marriage. This is the most common type of marriage to people who believe that they are enlightened. This is called the civil law marriage, or rather the general law marriage. In this type of marriage, parties either decide to pay roora or amalobola, or they say no, you don't want to pay the roora, and they just go before a marriage officer and they have their marriage solemnized under what is called the Chapter 5.11. That's an act of parliament. After solemnizing their marriage, the parties will now be in a monogamous type of relationship, which means there is no adultery which is allowed. If either party commits adultery, the other party, the injured party, is entitled to what are called adultery damages. And upon dissolution of this marriage, the parties go to the High Court of Zimbabwe and the divorce is dealt with in accordance with what is called the Matrimonial Causes Act. So basically, this is the type of marriage where most people say it's 50-50. In the coming series, we're going to be discussing on the intricacies relating to this types of marriages. But the question now is, why is the government of Zimbabwe amending or reforming the marriage laws as it were? You will understand that when I spoke of the Unregistered Customary Law Union, I say that it injured the woman. And I did not talk of the age of consent also in the Unregistered Customary Law Union, which means that a woman could be married at 15, at 14, at 13, or even a man could marry at a very tender age in an Unregistered Customary Law Union. And there would be no law to stop them from doing that, unless, of course, if you go the criminal law route. So what the courts, what the law is trying to cure in bringing up this act, number one, is to end what are called child marriages. Number two, is trying to eliminate what are called forced marriages. And number three, is trying to protect the woman. So in trying to bring these reforms, this is what the law has done. There are positive reforms in the new marriage bill, and there are negative reforms as well in the marriage bill. So allow me now to unpack the marriage bill as it were. You will understand that the new marriage bill now includes what we call the minimum age of consent in marriages, be it a customary law marriage, be it a civil marriage, or the formerly called Chapter 5.11 marriage, which means no one can now enter into a marriage before attaining the age of 18. If a child is married before that child reaches the age of 18, the parents will be liable criminally for selling out a child to be married before attaining the minimum age of consent. That's number one. Whether it's a girl or it's a boy, that's a positive reform. And number two, under the Act, we will realize that both the civil law marriage and the customary law marriage have been given equal status, which means that formally, as we said in the customary law marriage, a woman was entitled to what is called the Amai property. But under the new Act, a woman is now entitled to the same share of property as a man, which indeed is a positive reform in our Act. But the sticky point now comes to what is called clause number 41 in the amended or proposed new marriage bill. This clause brings upon what are called civil law partnerships or common law partnership or civil partnerships. When the bill came out in 2019, there was an uproar by people saying that small houses in court had been legalized through the marriage bill which was proposed in 2019. And the lawmakers in 2020 now came up with an amended marriage bill, and they are trying to correct the ills which were brought about in the 2019 bill. But we will realize that the mischief which they tried to correct still remains. Why do I say so? Section 41 or clause 41 says that a common law union or common law partnership or a civil partnership, as you may want, exists, number one, where both parties are not married either civilly or customarily to anyone else. This is quite clear. Number two, a civil partnership exists where both partners were not married to anyone else, either civilly or customarily, but the other partner thereafter goes on to marry someone either customarily or under civil law. If the person proves that they were in a partnership before that person was married, then indeed they are entitled to claim for damages under what is called the civil law partnership, or for sharing of property under what is called the civil law partnership. Another tricky point, if they had ended there, maybe it was going to be fine. But what then becomes interesting is that a civil partnership can exist even if either one of the parties to the civil partnership is married to someone else under either civil law or general law. What am I saying? It means that if Mr. X is married to Mrs. X under a civil law marriage, which is the chapter 5.11 marriage, Mr. X can now therefore go on to have a civil partnership with Miss Y. And that civil partnership is recognized under our law. Which therefore means that in light of the recent developments which say that lobola is not a requirement, it means therefore that if Mr. X gets into a relationship with Miss Y and they stay together, they have children together, or maybe they don't even have children, but they stay as husband and wife, giving each other the rights and privileges of a married couple. It therefore means that Miss Y can now therefore come and claim to Mr. X, saying that we were in a civil partnership and we want to dissolve this civil partnership. I'm entitled to a certain stake of the property that you acquired during the subsistence of our civil partnership. And what becomes more interesting is that Miss Y only has to prove that, number one, the property was bought using her money, A, or B, the property was bought using Mr. X's salary, that's number two. Or number three, that the property was bought using money or proceeds from Mr. X's company. Only where and this applies where Mrs. X is not part of the directors or the shareholders of that company in question. And another scenario is that Miss Y can now come and say, I want a stake in your property, if she can prove that she was a partner with Mr. X in a certain business that they were conducting. A question which might come is, how can one prove that house number A, house number B, house number C was bought using proceeds from my salary? House number B was bought using profits from a company which Mr. X and Mrs. Y own together. How can Miss Y prove that this house number C was bought using proceeds from a partnership agreement which we entered and a company that we formed together, herself and Mr. X, I'm sorry. So you see, there are various things which come into being, which makes it difficult for the courts now to then decide. Which means that Mrs. X and Mr. Y, Mrs. X and Mr. X can buy their property, and Miss Y can convince the court otherwise that, no, I was also part and parcel of the planning and the sacrifices which were made in the purchasing of this property, which then exposes women with civil law marriages, which was the very uproar which was made during last year's proposed bill. So the law has tried to protect these women who are in civil law partnerships, but it has gone further to expose women who are in civil law marriages. Their properties are no longer protected because Mrs. Y, as long as she has a good lawyer, she can take the whole estate, which you would have worked for. So the question now comes, this bill has been passed in Senate. It's soon going to be our law. How can we protect our assets? How can women in Chapter 5.11 marriages, which are soon to be called civil law marriages, protect their estates? The question now comes, how can we then protect women who are in genuine unregistered customary law unions who want to protect their properties? It's still a sticky point. Tune in next week, we are going to be discussing further on how to protect the properties that would have been acquired during the subsistence of the marriage, the properties which would have been acquired by women who are in unregistered customary law unions. How do we strike a balance? Thank you.